Hello and welcome back to LawTorn, the podcast which looks at what really happens when family fights turn into legal battles. My name's Samara Dutton. I'm a partner in our private wealth disputes team, and I'm joined by my co-host, Philippa Dolan, who is a partner in our family team. Hello, Philippa.
Hello, Samara.
And as I understand it, Philippa, you have got an interesting question for me today. Is that right?
I have. It came from a client who's actually should have come to you, really. It's your subject. It says, "Dear Samara, I do hope you can help me. My mother died recently and it was a terrible shock. It wasn't anticipated, although she has been housebound for several years and needed lots of support from carers and also from my brother who visited her every day. I live much farther away, so I haven't been able to see her very often. I've now discovered that my mother left a will leaving everything to my brother and nothing to me. This makes no sense because she and I always had a close relationship and she used to help with our mortgage when we were in financial difficulties and was a great support. I just cannot believe she'd do this to me. I'm worried my brother may have put pressure on her and he's always been rather jealous of our relationship. What can I do?"
This is definitely a question for me rather than you. Also, obviously, while we've got quite a lot of information there, there's a lot that isn't there. And then there's a lot more sort of facts that I would want to delve into with this client. So if I received this email, my first advice would be to have a conversation with me so that I could learn a little bit more about the background before I advise. But subject to that, my mind is going in two directions, both of which I expect we can explore in this podcast. The first would be potentially a will challenge, and just on the information that she's provided, the suggestion here is potentially that there's been some sort of undue influence by her brother on their mother to produce this new will. The second, just because she mentioned some financial assistance that her mother had previously given her, would be to question whether or not she might have a claim under one of my favourite acts, which is the Inheritance Provision for Family and Dependants Act 1975. Yeah, so that is where my head is leading straight away. Which one are you most interested in, Philippa?
So 75 Act claims, which is what I've always thought of as challenges to wills. Tell me the difference between a 75 Act claim and a will challenge.
Yes, they are different. A will challenge claim can be brought under sort of 4 or 5 heads, one of which is undue influence. And what you are saying is this will is invalid for one of these reasons. And obviously, one of the reasons that a will might be invalid is because the person who has executed it and had it witnessed and followed all the proper formalities didn't actually want their will to say what it currently says, because they've only put that down because they are being heavily leaned on by somebody who they rely on or for whatever reason are, vulnerable to or answerable to. So
Can I say then,
yeah.
because you said leaned on, I imagine someone literally leaning on someone and putting a gun to their head. Is that a will challenge if someone signs a will, not because someone is making them think they've got to leave the money to them, but is actually threatening them and making them sign a will? Is that all under will challenge, but a slightly different type of will challenge?
All of that, if I'm interpreting what you're asking correctly, all of that would come under an undue influence will challenge. It's a very fine line.
Yeah.
And the law is against those trying to make out that somebody has unduly influenced the testator, the person who's left the will. Yeah.
For obvious reasons. They want to keep everyone out of court, and because there are a lot of unhappy people who just their parents or whoever it is didn't love them as much as they thought they did.
Exactly. It's a difficult thing to prove. And the test is there's quite a high bar to the test. So you have to overpower the volition without convincing the judgment. That's a quote, I think, from one of the judgments, and may not make that much sense. But it means that in order to establish undue influence, you need to overpower the physical act of somebody signing and executing the will without persuading them in their mind that is the will that they want to sign. So they end up doing the physical act of executing a will, knowing that they don't want that to be their will.
Yes, I do understand.
And that is separate. That's different to guilt tripping somebody into saying, look, remember how many things I've done for you. You're entitled to try and persuade someone to leave more to you. And if that persuades them that actually, you're right, you have done a lot for me and I haven't recognised you enough, and perhaps your sibling hasn't been there for me so much. There's nothing unlawful or illegal about that. If they then change their mind, they are entitled to then change their will accordingly. So all of that comes within an undue influence will challenge.
Yeah.
Now, 75 Act claims are very different because you're not trying to undo what is there. You're not saying this will is invalid, or you're not saying that the estate shouldn't have been left intestate because there is a will, or you're not trying to change the status quo. What you are
intestate means without a will.
Yes, sorry. Yeah. So you are accepting what the position is as regards to somebody's estate, but you're saying, but that distribution of their estate did not make enough provision for me. And I, therefore, am entitled to go to court and say to the court, look, this is what I was left and it's not enough for me. Therefore, please give me more.
And in this case, it was nothing. So this client, this poor client, used to get some financial support, it looks like, on and off from her mother. And now, of course, if she's died and everything's gone to her brother, then she will have a financial issue as well. So is that something that would give rise to a claim under the 1975 Act?
Very, very possibly. So for the 75 Act, you have to be you have to be in a certain type of relationship with the person that's died. So you have to fall under a certain category in order to be entitled to bring the claim at all.
What are the categories?
So
could a neighbour?
No, well, possibly. As with all things legal, it's the answer is not straightforward. Spouses and civil partners, firstly. Children next. So this client is certainly in. And then other dependents and people who have been being maintained by the deceased at the point before they die. So yes, as a child, you are certainly entitled to bring a claim against your parents' estate under the 1975 Act. As an adult child, in order to bring a successful claim, to persuade the court that leaving you with nothing was unreasonable and that therefore you should be given something.
Oh, unreasonable. I mean, it's just such a kind of nebulous term. If you hate someone, it's not unreasonable not to leave them anything.
Well, exactly. And this is the huge issue that we have with 1975 Act claims, because they butt up against this principle that English law has always been founded on, that we should have testamentary freedom. Every individual should be entitled to leave their assets exactly as they wish. We don't have a forced heirship regime like they do in more civil jurisdictions. We've always sort of stood firmly by this sense that it is right that whoever you are, you can be my child, you can be my best friend, you can be my husband, my whoever, if there is a good reason why I do not want you to receive anything that I own after I die, then I ought to be able to leave wishes to that effect, and they ought to be followed. And that's a honourable principle to base legislation, etc., on. But the 1975 Act is the only bar to that principle in our jurisdiction. And its purpose, which I'd always thought was quite sort of fluffy and kind and giving, is to some extent that. But I think also it's more about ensuring that where somebody dies who has obligations to family members and children, that those are obligations to the extent that they're financial don't fall on the state instead. Cynically.
So it's reducing the welfare bill.
Exactly, because so where you can prove that you've been maintained by somebody who's died and that you will struggle financially now that they've died and left you nothing, then you've got a good chance of getting something. But I mean, we shouldn't get too excited about this, because other than for spouses who are treated slightly differently, any of the other claimants that can make these types of claims, if they are awarded something, it's always limited to what they need for their maintenance. So these aren't huge awards. In very valuable estates, they may be greater, because one of the things that's taken into account is the size of the estate. But normally these type of claims fall to be made against relatively modest estates, and often there are competing beneficiaries of those estates, all of whom have various needs. And it's about balancing that and making sure that everyone's sort of got enough to get by on as far as is possible.
Presumably keeping in mind that the starting point is people should have some freedom to leave their money as they want to. So, so the judge wouldn't want to just completely ignore the wishes of the person who's died.
Ostensibly. But there have been cases where that does appear to be exactly what the judge does. But the thing is with 75 Act claims, they are, in reaching their decisions, the judges are directed to this sort of list of things to take into account. And the final one of those is anything relevant to these circumstances. So they're directed to take into account everything. So all of these are very fact-specific decisions. It's really hard to predict how they will develop.
So would breast implants be a requirement if someone wants them?
It's interesting you should ask me. You see, on the face of it, I would have always thought no, because that seems like a sort of a luxury or an indulgence, and that isn't necessarily, well, it isn't what these types of claims are supposed to be about. But as you say, there has recently been a 1975 Act claim where an adult child claimant was successful and received a judgment awarding her about £125,000, I think, of which part of it, so that the judge in that case, they don't always, but the judge in that case kind of broke down how he had come to this figure for her award. And part of that was for breast implants, because it was, or he deemed it to be necessary for her sort of mental health and well-being and confidence, etc. I mean, there was obviously medical evidence available that this really was impacting her. So it was seen more as a kind of just maintenance in terms of ensuring that she was okay in herself. I think it was fed that way.
Her deceased father have gone along with it?
I very much doubt it, because I think he called her lazy, druggy, something else. So, I mean, this was exactly what you were talking about earlier. The deceased father in this case had been very clear that he didn't want her to inherit anything at all. And yet she came out with something at the end, including sufficient for
Mhm.
a boob job.
Yeah. Extraordinary. So we've come a long way since 1975. I don't even know if we had breast implants in 1975.
The 75 Act actually, very boringly, has roots in much older acts. As I say, all of it to do with ensuring that people aren't sort of left out to pasture and then have to be looked after by the state because they've been disowned or, I mean, hugely historically, probably where you had sort of illegitimate children and people like that, you would need to rely on this act or the equivalent of it, to get some provision from somebody's estate.
So pre the 75 Act, there was legislation that forced those with wealth to support their impoverished relatives.
Yes.
Wow.
Well, in certain
They
circumstances.
didn't all have to go into the workhouse.
No, I don't believe so. I can't remember how long it goes back.
That's interesting. What would have happened if this poor woman's mother hadn't left a will? Because we're assuming she changed her will, but suppose she hadn't left a will.
Well, and also suppose that this poor woman is able to challenge the validity of this will, if she is able to establish that the brother has somehow procured it in unusual circumstances, then what happens is that will is invalidated and you go back to any prior will. So if there isn't one, then the mother's estate would pass under the intestacy laws, which, again, we haven't got all the details.
Yes,
But
there might be another couple of siblings hanging around.
Yeah.
But she's left everything to this brother,
so you assume not. So presumably it then would, just on the facts of this case, it would pass 50-50 equally between them. So, if you were advising this client, and obviously, as I say, it will depend on additional information, but there might be a sort of strategic decision to make here about what is the better claim to bring, because you can't really
bring both.
You can't really bring both. I mean, you can, and you'd have to make them alternatives though, because if you invalidate the will with an undue influence challenge, then you don't need a 1975 Act claim. But if you are unable to invalidate the will with your undue influence challenge, then you do need a 1975 Act claim. And do you really want to pay for both claims to run? Because it's different evidence, it's more work, it's tricky. It would be a tricky decision. But obviously the will challenge, if successful, is likely to bear more fruit.
And of course, the most important issue is how much is it worth?
Yeah, the estate.
If the woman's left £20,000, it's going to be swallowed up in costs.
Exactly.
So, and then, wearing my mediator's hat, maybe the brother and sister should get in a room and see whether they can come to an agreement.
Yeah. Discussion, negotiation, sort of thinking about settlement terms is encouraged throughout all my litigation, and presumably yours as well. Not least because the courts and we as lawyers recognise the devastation associated with the amount of costs that you spend, and just the pain and sort of harrowing nature of having to argue.
Reliving your childhood or whatever it might be. And yes, absolutely.
Yeah. So yes, by all means. I mean, but they would need to, in a way, there's nothing to mediate yet because we haven't started the argument. So you sort of have to start the argument before you can try and settle it.
And we'll say no more about it.
Yeah, we should try.
Yeah.
But absolutely. But yeah, no, and the interesting thing about 75 Act claim for this woman is that it would fall under the category of adult-child claim. And sort of for a while there was this sense that those are very difficult claims to bring, because it was assumed that the sort of courts say, well, hang on, you're an adult now, and you ought to be able to stand on your own 2 feet. And so actually, if your parent is saying that there is a good reason why I don't want you to get any of my estate, then why on earth should you be able to come now and claim against that estate? So they've always been, 75 Act claims are sort of unpredictable, and therefore you're always a bit cautious about advising people to go for it anyway. But adult children claims specifically, you would be even more worried about pushing anyone to sort of go down that route, just because it may not work in their favour. But there's been a bit of a flurry of cases in the last few years where adult children have actually succeeded. But as I say, it is at these more modest sums and always only for maintenance. So there is still good case law that says you cannot be sort of adult child that behaves in an entitled manner. And then, so there was one case, I think, where there were two sisters and they did have some health issues, and they tried to make out that these sort of meant that they couldn't work themselves. But their father had given them significant sums during his lifetime, and in each case a sort of a final sum. Right, here you go, that is all you're getting from me during his life. And then when he died, they both brought these claims against his estate for more. And so in that case, the court was like, absolutely not.
Can you remember who he did leave his estate?
Yes, their stepmother.
Well, that's a whole new...
Who quoted Shakespeare in her witness evidence, I think. So, sharper than a serpent's tooth is an ungrateful child, or something, which I always quite enjoyed.
Yeah, no, it's all of life is in those cases.
Yeah, yeah, for sure. So yes, she scooped the pool there because the court just inferred from their evidence and the way their cases were presented that actually this was just a try-on. They'd got used to having money from their dad. It'd been very clear to them that they'd had what they were having and that was it, and yet they still tried it on in any case. So because
and as always, being sort of likable, judges are people, and it makes such a difference. So you've got these two sort of bitter women who don't like their stepmother, and you can just see the judge thinking,
You can, but as you say, in a different arrangement where the two daughters were likable and jovial and jolly, and and the stepmother didn't come across well, that a different decision could quite easily have been arrived at. Because there was, as I say, I've forgotten the complete details, but I do remember there was the grains of a reason why they couldn't work. It wasn't completely without evidence. So it was still quite reassuring, I think, that the court will sometimes make the decision to just throw the claim out altogether. Because we sense, I think, as advisors, that there's always a risk that these claims will succeed, or on the other hand, from the other way around, that you don't want to write off a claim because it might get something for your client. But it's never very clear cut, and so you end up sort of telling people, certainly on the receiving end of a 1975 Act claim, that there is, that there's always a risk that the claim will result in money going to the person claiming, and that therefore it might be better to sort of explore settlement early on, even when those claims look like
fizzing with anger and rage.
Yeah, even as the lawyer, not the person who's experienced the relationship with this person, but you can see just on the papers that this person is trying it on. But if they've got enough of an in, there's always a risk that they might, on the day.
Do you think honestly, you probably won't know the answer to this because it depends, but do you think some judges think, I'd really like it to go to the RNLI or Save the Children, or what? There's a sort of element of they quite want a charity to get it.
The judge?
Yes.
I've never thought about that.
Do you see what I mean? Yeah. So leaving it to a not terribly nice stepmother may be different from leaving it to some wonderful charity that's saved people's lives. And, so again...
So you think that's the alternative. If it doesn't go to you, it will end up in a charity. Yeah, and potentially if the judge had affiliations or felt, that was an important charity, that might influence the way they feel about it.
It's all random.
Yeah.
It's all a gamble.
It is. It's all just people at the end of the day, as you say, making decisions. But just on charities, one of the main cases in the sort of litany of 75 Act cases was a Supreme Court judgment from 2017. And what happened in that case was it was a similar scenario where the claimant was the daughter. Her mother had left the whole estate to charities that she'd chosen, and been very, very clear in her letter of wishes that she did not want her daughter to get anything. They had been estranged for 25 years, etc., etc. The daughter brought this claim and was awarded $50,000 at first instance. She appealed because I think that amount was going to take her out of a benefits bracket, but not give her enough in order to sort of go. So she appealed that, and the Court of Appeal awarded her slightly more. And then on charities, the charities appealed that. So I think we were only talking about sort of, well, I mean, you know, a £450,000 estate. The Court of Appeal had awarded her about 125, something around there. And the charities appealed, which is unusual for charities. They don't usually like this sort of publicity.
No, but they do have an obligation, don't they?
And they do, yeah. It's trusting,
to the people who are going to benefit.
To their objects, etc. So as a group, they appealed, and it went to the Supreme Court, who didn't really clarify the law to any great extent, and did say this is all very fact specific. Yeah. But they reinstated the original 50,000. So she still got something, but possibly
who paid the cost?
I can't even imagine who paid the cost of that.
Supreme Court.
Exactly. It must have been done on some sort of pro bono basis. I just don't know how it works otherwise.
Anyway, it's fascinating.
Yeah. Well, there you go. So to the woman who wrote in, call me. I think that's the answer.
I think that is the answer. Well, that was really interesting, and I do hope this woman can get some help. And that's all from us for today, but do join us for our next episode.
Bye.
Bye.